Good day, madam. My name is Lakshanya, and alongside me are my group members, Farhana, Intan, Sharadini, and Kaichen from Tutorial 9, Group 1. The topic of our presentation today is the legal problems of computer networks and its relationship with e-commerce. We will also be diving into how e-commerce relates to intellectual property and jurisdiction. Electronic commerce, also referred to as e-commerce, involves the online buying and selling of goods and services by companies and individuals. The widespread connectivity of the internet breaks down geographical boundaries, and while e-commerce offers many conveniences, it also gives rise to various challenges and concerns. With that, allow me to begin with the first issue, identity and anonymity. Identity is closely related to intellectual property because it deals with the identity and the conception of a human mind, which would be the business idea in relation to e-commerce. Anonymity, on the other hand, is defined as the state of remaining unknown to people. The identity of e-commerce would be the business's or company's trademark, which is its logo in the form of a word, letter, shape, or even color, as per Section 2 of the Trademarks Act 2019. As such, when identity theft in e-commerce occurs, it would be similar to a trademark, copyright, or patent infringement. For instance, in Malaysia, according to the Corporate Executive Officer of Cybersecurity Malaysia, CSM, back in 2018, most of the reports were on identity theft, accounting for almost 40% of the reports. Anonymity also poses an issue because it allows cybercriminals to use the anonymity feature to commit cybercrimes such as frauds and even scams. A landmark case on online fraud in Malaysia is the case of Juma and Shroff. The first defendant, who is the anonymous fraudster, had hacked the plaintiff's email and committed fraud by deceiving the plaintiff into depositing money into the second defendant's bank account in Malaysia. Meanwhile, the plaintiff believed he was paying the commission to its South Korean business partner. Apart from that, another example of an online fraud case is the English case of CMOC Sales and Marketing Limited. In this case, a group of fraudsters had hacked into the plaintiff's company email system and committed fraud in which substantial sums were stolen from its bank account. As a solution to the identity and anonymity problem that gives rise to e-commerce issues, as I've explained above, in Malaysia, there are certain legislations that provide for cybercrimes. For instance, Section 3, Subsection 1 and Section 4 of the Computer Crimes Act 1997 criminalizes unauthorized access to computer materials and unauthorized access with intent to commit or facilitate further offense respectively. Furthermore, Section 8 of the Personal Data Protection Act 2010 restricts the disclosure of personal data without the consent of the data subject for any other purpose than the collected and its related purpose. In addition, Section 416 of the Penal Code provides for the offense of cheating by personation. However, this does not completely resolve the anonymous offenders issue, as it only enhances the process of identification and proving of true anonymous offenders to an extent. However, it should be noted that there has been no precedent under Section 416 of the Penal Code yet for cybercrimes. As such, this provision should be better implemented for cybercrimes so identity theft issues can be curtailed. That will be all from me. I would now like to pass the floor to Farhana to continue.
Thank you, Lakshanya. The next issue is in terms of attribution. Attribution is concerned with giving credit and respect to the original inventor or owner of a product, design, or content in order to acknowledge and honor their intellectual property rights. Proper attribution calls for explicitly identifying the actual author or owner of each item. For instance, if an e-commerce platform permits third-party vendors to display products. This not only protects the creator's intellectual property rights but also forbids the misuse or distortion of their work. An illustration of this issue can be found in the case of Tiffany against eBay, where in this case the defendant was a website operator that ran an online flea market, was sued for trademark infringement against the plaintiff. The issue was whether the defendant was liable for direct trademark infringement by imitators using its website. It was decided that the defendant's knowledge that the Tiffany knockoff jewelry was being sold on its website was inadequate to support a claim against the latter, since the latter was unable to find and take down all of the listings that Tiffany alleged to be fake. By doing so, it would have unduly impeded the legal resale of authentic items. Plagiarism is also another prime example of when someone uses another person's work and presents it as their own. For instance, if an e-commerce website copies product and description from another site without giving credit, it constitutes plagiarism. A notable case involves a blogger who sued a clothing company for using her photos to promote their products without consent and without acknowledging her as the photographer. This incident was reported in Malaysia Kini Team's article titled Dentsu Reject Plagiarism Charges, Resigned from 4As. To solve the issue of attribution in e-commerce, we can follow the new initiative from the European Union Intellectual Property Office that provides a customer-focused IP hub that contributes to a stronger IP system, efficient enforcement, and a better understanding of IP rights in a global and increasingly digital environment by building and promoting sustainable networks, thereby supporting competitiveness, innovation, and creativity in the European Union. In Malaysia, on the other hand, there are current laws in place that actually protect the rights of intellectual property owners under Copyright Act 1987 and Trademark Act 1976. With that, I would now like to pass the floor to Sharadini to continue on the next legal problem. Thank you.
Thank you, Farhana. The next legal problem is known as non-repudiation. Non-repudiation refers to a legal concept that ensures undeniable evidence of authenticity and integrity which affirms the credibility of a communication or data transfer. It is commonly employed in information security to establish the source and trustworthiness of data. In essence, non-repudiation guarantees the origin, validity, and integrity of specific data that cannot be disputed. Digital signatures play a crucial role in e-commerce by providing non-repudiation, which ensures that a party cannot deny the authenticity of their signature on a document or the act of sending a communication. Non-repudiation in this context refers to the ability to guarantee that the party involved in a contract or communication acknowledges the validity of their signature on a document or the sending of a message. The validity of an electronic signature is provided for under Section 9, Subsection 1 of the Electronic Commerce Act 2006, Section 3, as well as Section 66 of the Interpretations Acts 1948 and 1967. Non-repudiation, however, poses the issue of how to verify that the person you are speaking with when signing a contract is who they say they are, as well as whether an imposter could bind you to an electronic contract. The recent case of Market Land Proprietary Limited against Blackburn provides examples of fraud in the context of execution of electronic documents as well as suggestions for reducing the risk. In this case, it was found that Matthew had exploited Sarah's account to sign the contract without her knowledge or consent using DocuSign metadata, which is a platform to sign signatures digitally. The judge in this case determined that the emails sent to Sarah's business email address needed to be accessible to the individual utilizing Sarah's DocuSign account. In the present case, emails sent to Sarah's business email account were accessible to both Sarah and Matthew. There was no password or any other type of authentication in place to prevent unauthorized access to Sarah's DocuSign account, such as sending a text message confirmation code. The DocuSign account holder was not informed that a new device had accessed their account. To solve the issue of non-repudiation, new business trends have required a reconsideration of how to sign electronic documents to serve the function of authenticating and identifying a person who made a particular promise. Firstly, by using public key infrastructures, which is a system of digital certificates, certificate authorities, and other supporting components that enable the secure exchange of information over the internet. Secondly, by establishing legal frameworks and agreements that explicitly address non-repudiation in e-commerce transactions. Contracts, terms of service, and user agreements can include clauses that define the responsibilities of each party and explicitly state the non-repudiation requirements. These agreements help reinforce the legal standing of e-commerce transactions and provide a basis for resolving disputes. That will be all from me, and I would now like to pass the floor to Intan to continue. Thank you.
Thank you, Sharadini. The next legal problem is in terms of authentication. In the realms of e-commerce, it's necessity that both of the vendor and the customer to be genuine individuals. They must apparently represent their identity. The company should be capable of offering proof of its legitimacy, valid business operation, and fulfillment of obligations. Customers should provide identification document to ensure the seller of the authenticity of their online transaction, thereby ensuring confidence in the process. However, this is where the problem lies, in which sellers are unable to authenticate their buyer as every transaction is done online. Hence, sellers do not have access to buyer's details, leaving uncertainty and doubt as to whether there is someone's legitimate purchasing their product or is just a scam to receive their product with no cost incurred whatsoever. Having said this, it is important to know what is transaction authentication. Transaction authentication is an online technique for identifying account users and confirming their authorization for a given account. In order to confirm authorization, the system often asks for specific information such as a password and user identification number. In the most case, the inability of seller to authenticate buyer leads to a leak of data. The accidental release of data by employee due to authentication issue is evident in the case of Gibber against Twitter. In this legal case, a Twitter user filed a class of action lawsuit in the federal court in California, claiming that Twitter failed to safeguard the personal information of 200 million users over a 6-month period.
In July 2020, hacker used a spear phishing technique to gain access to 130 Twitter accounts belonging to celebrities such as Barack Obama, Elon Musk, and others. The hackers stole passwords and administrative tools through phishing, changed their login credentials, and tweet fraudulent Bitcoin offer to millions of followers. They also transferred $180,000 worth of Bitcoin to fake account. To address the challenge of authentication in e-commerce, sellers can adopt the use of two-factor authentication. This is where users enter their login details. They receive additional instruction through SMS and email. This extra step prevents fraudulent individuals from gaining access to legitimate user accounts since they require more than just username and password. Another solution is to obtain secure server layer certificate. This certificate encrypts sensitive data transmitted over the internet, ensuring that only the intended recipient can access it. This is crucial because data need to pass through multiple computers before reaching the destination server. Without SSL certificate encryption, any electronic device between the sender and server can potentially access sensitive information. This could expose username, password, credit card number, and other data at risk of being compromised by hacker. With that, I would like to pass the floor to Kasim to continue on the last issue. Thank you.
Thank you, Intan. Lastly, there is the issue of jurisdiction in e-commerce. Jurisdiction defines the legitimate scope of governmental powers as it covers the authority of the state to establish, enforce, and decide on violations of the law. In this day and age, the rise in technology has allowed e-commerce to be evolved. Hence, an issue arises on how can a law of a particular jurisdiction be enforced when an issue of e-commerce arises in a foreign jurisdiction and which law would prevail. Regarding our first issue of which court has jurisdiction, in Bank Bumi Putra Berhad and International Team Council and another, it was established that Order 11 of the Rules of Courts 1980 confers discretionary jurisdiction upon the court to permit the service of court proceedings outside its territorial jurisdiction, so long as the action falls within one of the subparagraphs of Order 11, Rule 1 or Rule 2. According to Order 11, Rule 1C and Act of the Rules of Courts 2012, the courts will only grant a notice of place outside of its jurisdiction by assuming jurisdiction if, number one, the website in question is within the server in Malaysia, or number two, the defendant is carrying on a business in Malaysia, or number three, the defendant is a Malaysian resident. While Order 11, Rule 1 mandates the physical presence of the defendant in Malaysia or the being located in Malaysia, complications arise when dealing with non-resident defendants in e-commerce contracts conducted online. This is because identifying the trader and determining their location becomes challenging as the trader may not be readily identifiable and the website accessed by the consumer may be situated in a different place altogether. Once the court establishes its jurisdiction over a case, the issue to be resolved is a determination of the substantive law, commonly referred to as the choice of law, that governs the contractual relationship between the parties involved. Referring to the 1796 landmark case of Giner and Mayer, it acknowledged that parties are free to expressly select the law that governs their contract during its formation. This common law principle has been adopted in Malaysia. However, the historical origins of conflict of laws principles do not specifically address consumer protection or welfare, since commercial transactions at that time primarily involved business-to-business interactions rather than business-to-consumer relationships as found in e-commerce transactions. Hence, this principle is not viable in e-commerce, as if contracting parties are allowed to choose any law without check and balance, it would be very dangerous to the consumer, as when he agrees to a foreign choice of law in an online contract, they are accepting the legal system of that country, which can be unfavorable due to their limited knowledge of the foreign system. Additionally, the cross-border nature of e-commerce contracts can give rise to the need for enforcing a judgment obtained in one country in another country. The issue that arises with a foreign judgment is whether it can be enforced in a different jurisdiction. In Malaysia, the Reciprocal Enforcement of Judgment is regulated by the Reciprocal Enforcement of Judgments Act 1958. However, this enforcement agreement is limited to a selected number of countries, including the United Kingdom, India, Hong Kong, Sri Lanka, and Singapore. The issue of consumer protection arises when laws safeguarding consumer welfare cannot be enforced due to their unenforceability in another jurisdiction, regardless of how comprehensive those laws may be. Such unenforceability leads to two main issues. Firstly, the legal system would be unable to remedy the problem that it aims to resolve. And secondly, the knowledge that the law cannot be enforced diminishes the normative power of other laws. As seen from above, it is evident that there are many prevalent issues when it comes to jurisdiction in e-commerce. Although we may have certain laws in place to resolve such issues, it still does not deter from the fact that these conflicts of laws put consumers at a disadvantageous position. To conclude, there are prevalent issues regarding e-commerce in relation to the 5 legal problems of computer networks. As such, with better compliance and implementation of the solutions provided above, computer network problems may be overcome and will reduce gradually. That is all from us today. Thank you, madam, and have a nice day.